Find them?
I don't see Bill at all. I don't think
Waiting
so.
for Bill.
Here we come.
Oh, yeah, he went in the other one.
Okay, we'll start. Good evening, ladies and gentlemen. Welcome to the City of Gloucester Zoning Board of Appeals meeting of March 25th, 2021. This will be a remote public meeting held on Zoom and will be video and audio recorded. Consistent with the governor's orders suspending certain provisions of the open meeting law and banning gatherings of more than 10 people, this meeting will be conducted by remote participation to the greatest extent possible. For the record, this is Zoom meeting ID number 811-1684-0601. Recognize in attendance myself, Joe Parisi, Michael Nyman, Adria Pratt, James Gelati, Peter Canavo, and Catherine Schlichty. Therefore, we all members of the board, and we have a quorum. Our first order of business is the approval of the minutes of the March 11th, 2021 meeting. Are there any corrections or omissions?
Mr. Chairman, I move approval of the minutes from the March 25th meeting, March 11th meeting.
Motion made,
Muted, Michael.
I'll second that motion.
made and seconded, roll call vote.
Ms. Schlichty,
Yes.
Ms. Pratt,
Yes.
Mr. Nyman,
I was not present at that meeting.
Mr. Canavo,
Yes.
and Mr. Parisi.
Yes. Okay, minutes are approved. Now we'll move into our old business. The first continued hearing was the petition of Kimberly Mackey and John Rogers appealing the decision of the building commissioner concerning a zoning violation involving a deck at 6 Mount Vernon Street. Our
Mr. Chairman, just for the record, I'm still recused on this matter.
And
Mr. Chairman, if I may,
yes,
at the last meeting, we were waiting for Ms. Mackey to present us with some more evidence as to what existed at that deck at the time. And she said she would do so. The only conversation, or not even conversation, contact we had was today around noontime. The mayor's office called and told me that pictures were dropped off for this project, and I believe you board does. However, the pictures just show the deck as it is now, with a couple of chairs squeezed onto it. There's nothing that really shows us what was there prior to them altering that deck. So at this point, we don't have enough evidence to go any further to make him take any more of that deck off than he already has.
okay. Our Miss Mackey, Mr. Rogers, if they are, they can raise their hand.
Can everybody mute that as well? Okay.
Ms. Mackey does have her hand raised.
She does. Can we? I don't have her. Can we bring her in?
Yep.
Oh, there we go. Can you hear me now?
Yes.
Okay. Yeah, I just dropped those pictures off
Can
today.
you state your name and address for the record?
Oh, sorry. Yep. Kimberly Mackey, 139 Bray Street. I did drop off those pictures. I know when we talked about last time, Mr. Sanborn and I had thanked him and I appreciated from the beginning of the start, like he said in the meeting minutes on February 11th, that he had apologized it took so long, which was appreciated. And, you know, he said they knew from the beginning that it didn't meet. It was too close. And, you know, they had been working with us since the beginning. And then I had asked about, you know, the refund because he knew at the beginning. And then I got the letter denying that I had to file this appeal and pay the $250, when from the beginning, we had been working together. I've been working with Ms. Sanborn and Greg, and everything had been going along smoothly, and they knew the whole time. So I didn't understand why we got denied, and we shouldn't all be doing this case. But the other thing with the pictures, I showed him the pictures because, we have to all admit here that it's really an unrealistic burden of proof for me to have pictures from before of the deck. I don't think anybody here has pictures of their neighbors' decks in their neighbors' backyards. I think the proof is very sufficient. We're not in like a criminal law thing here, but that's why I dropped those pictures. If you see those pictures, that the wood is all brand new. That's why I dropped off those pictures. You can see the wood, and I showed on both sides from where the wood starts at the top of the stairs, goes around to where it meets the other side of the deck, like behind their stairs going up. In all reality, it's an unrealistic burden of proof to say. I don't want to repeat myself, but it's all brand new wood. It's never been weathered. And if you look at the pictures, for him to say that was there, you can't barely fit those two chairs and the table. They're up against each other. Like no one could sit in those chairs and have the table there. So that right there to me speaks volumes that deck wouldn't have been there. You would have made it a little bit bigger.
All right, so I'm going to stop you for a second. So we had asked you to provide
I
us
said I'd
with
get
some
pictures, right? I said,
more
but the thing,
information.
right,
We-
but that's all I
Can
could
I
really come
please
up with.
speak?
Oh, sorry.
We'd asked you to provide us with information for this continued hearing. Which our
Right, just for
guidelines-
pictures.
Please, are
right.
you going to keep interrupting me?
No.
Well, I'm going to mute you in a minute then if you're not going to let me finish talking. We asked you to provide us with information. Our rules state that we need that information 72 hours before the meeting. We just received those pictures tonight, 15 minutes ago, and I don't know that any of the other members who we forwarded the pictures to has had a chance to even look at them. So whatever you're discussing now, no one has any idea what we're talking about.
I
And
apologize.
therefore, it's going to be continued again. And so that people can have an opportunity to look at things.
Okay.
And I was out there in the beginning. I kind of know where it was at that point. I'm going to go out again and look. And if it's been moved back from where it was when I looked at it in the very beginning, and then I don't know what else you could prove to us, or that we couldn't just decide to take the deck off because it would just be appealed, we'd lose. We have no documentation. So I'm gonna ask for a continuance on this.
Okay, I just want to apologize for that. I just got out of the hospital today. I actually just got home from Beverly. I've been in there all week with a cardiac issue, and I had to have a cath, but I do apologize. I did plan on doing it earlier. And if they do want to do that, would be fine. And that's the only thing I ask is just look at the wood. It's obviously brand new wood. And unfortunately, that's all I can really provide. I apologize. But like I said, no one would normally be. I gave you that Google view. And like you told me last time, you can't really see, which I get it. But the Google, you can just see one set of stairs
Okay.
there. And I passed that in last time for proof. So
All right.
So I just wanted to let you know that if they can look at the pictures and you
We're
can
gonna-
see it's brand new wood. It's brand new wood.
I know, but there was brand new
Okay.
wood in the beginning because they cut off the deck and they had to shore it back up with new wood. But anyway, I'm gonna look for a motion to continue this to April 15th.
Mr. Chairman, I move that we continue 6 Mount Vernon Street to April 15th.
Second,
Motion made and seconded, roll call vote.
Allison, you need to do the roll call, please.
Mr. Gelati,
Yes.
Mr. Canavo,
Yes.
Mr. Nyman,
yes.
Miss Pratt.
No, she's recused.
Oh, that's right, sorry. Miss Schlichting,
Yes.
Mr. Bracy.
Yes. So it's continued to April 15th. There are some pictures that came in that everyone will get sent to them.
I apologize. Like I said, I've been in the hospital. I will get some more issue some more proof from previous tenants I've talked to. The meter maid, Julie, said she would be willing to say only the stairs were there. And I will, but like I said, I just got out from a cardiac cath. I just got out of the hospital about 2 hours ago. So I do apologize for the delay.
Go lay down.
I am. Thank you all. We'll see you on April 15th.
Okay, moving on to our next hearing, continued hearing, the petition of David Higgins, seeking a special permit under 1.9 to alter and expand a non-conforming structure to allow renovation of existing structure at 6 Dooley Street. This had to have been, was re-advertised, and the applicant's represented, I believe, by Joe Luna.
Mr. Chairman,
Yes,
so this has not been heard yet, 31 Magnolia
No.
Avenue? Okay, good.
Catherine, this is 6 Dooley Street, not 31 Magnolia Ave.
yeah, they both came up and they hadn't been advertised right.
Thank you.
So we pushed them out, yeah. Mr. Luna?
Yes, can you hear me?
Yes, name and address for the record, please.
Yes, my name is Joseph Luna. My company's name is Luna Design Group. We are the project architect. Our address is 100 Conifer Hill Drive, Suite 406 in Danvers. Zip code is 01923. Representing our client, David Higgins and his wife Joanna Liu. The project involves a non-conforming structure that we are essentially doing a full renovation to. It's a very small house on approximately a 650 square foot footprint with a total square footage of 1,057. We're essentially rebuilding the roof and adding 3 bays on the northwest side. Total increase in square footage is only 185 square feet. We are maximizing space inside the upper floor by adding 2 shed dormers on the northwest and southeast side, and on the northwest side to make it more architecturally interesting. We've provided what we call bookend dormers and a center bay window that's projecting into a very close side yard. We are not exceeding the height of the existing house, but we are providing a roof deck on top of that. Will be accessed via an internal ship's ladder. There's no alteration to the existing footprint other than, again, these projecting bays at the second floor and the larger bay at the first floor. My client has reviewed the project with the neighbors, 3 letters of support from Jen Franco, Barbara Job, and Lynn Klotz. Respectively, 3, 8, and 5 Dooley Street have been submitted in support of the project. We are just on a very tight site to the side yard and to the front yard. But again, we are not altering the footprint. We're just basically building on top of what's there. But again, to give some visual interest on the primary facade facing out toward the water, we did add those small projecting bays. And I should say the bays project out of the upper floor, essentially 8 inches from the face, and then the larger bay at the ground floor is roughly about 2 feet. Be happy to answer any specific questions about the project.
Okay, any questions of the applicant at this moment from the board? So the overall height, even with that deck, is, what's your average height now?
Our average height is below your threshold here. Let me give it to you, it's below our application. 25.8 to the deck line. Obviously, the rails are higher, but the deck elevation is 25.8 average grade.
Already,
We're matching the ridge line of the existing house. We're just maximizing the headroom with the dormers.
anyone else, questions by the board? Okay, we'll open up to public testimony. I'll remind everyone, if you're on a cell phone, you dial *9 to raise your hand, alert us. If you're on your computer, there's a raise hand button. Anyone that wishes to speak in favor of the project, please raise your hand. First one up I see is Doug. We could bring him in.
This is Barbara Job. I'm at 8 Dooley Street. And
Are you on as Doug?
Yeah,
Okay,
I'm on his computer.
I'm not hearing you well. Can you speak in there better and name and address?
My name is Barbara Job, and I live at 8 Dooley Street,
you.
directly abutting what Dave is doing. I sent a letter into the zoning board stating that there might not even be 2 feet between his property and my property line at the bay. So if he puts in a 2-foot bay, it will probably be right
Ma'am,
on.
let me interrupt you, please? We're asking for people that want to speak in favor of the project at this point.
Okay,
So are you speaking in favor?
no,
Okay, so we'll hold on 1 second, then we'll complete. Anyone wishing to speak in favor of the project? Okay, I see none, so we will now go to people wishing to speak in opposition, and I'll recognize you again, ma'am.
okay. Have you read the letter that I sent to the zoning board?
Yes,
That is my concerns. I mean, I want him to at least make the bay 18 inches instead of 2 feet to keep it off my property line.
anything else?
Now, the dom is up above. Are they over the property line?
Can I answer that question?
Sure,
We are not over the property line. If you look at the survey that was prepared by Meridian, at the larger bay, which is 2 feet, projecting off of the house, we are at the site is tapering wider from the front to the back. So the closest dimension of the largest projection is 1/2 foot. And then when we get to the upper dormers, we go down to 1.2 feet toward the northeast side and 1.9 feet on that. So we are not encroaching over the property line. It would be illegal for us to do that. So we're at least 1/2 foot at the closest point projecting.
This is Doug Duquette, Barbara's son-in-law. May I address that, please?
yes, could you speak louder or closer because we can barely hear you?
Can you hear me now?
Yes,
Okay. So there is some disagreement as to the exact location of the property lines. Apparently, we have 2 independent surveyors that have some differential. So in the letter that Barb sent to the board, she specifically said, in any case, we want to make sure that there is a setback of a minimum of 6 inches for any structure that's being proposed to be built. So we just want to make sure that, and from the property line that we show, I think there's maybe 6 inches, along the line here and there. So when they say, well, we're 6 inches in, we are suggesting that perhaps that's not completely accurate according to the surveys that have been done on this property versus the surveys that Dave has had done.
did you have something to submit to us and factual on the survey?
Yeah, I mean, we
Yes.
have the surveys that were done and they.
And had you
are in
not sent
disagreement.
them in to us, or
I'm sorry, what?
and you didn't send them to us?
No, not at this time, because we have no way of, well, we can, but in addition to that, it wouldn't necessarily be, it would only be representative of the survey that was done here with the existing structure as measured from here that exists. And the new structure that is proposed, and the drawings that they've submitted are to the lines that they believe are true.
With respect to the survey was prepared we had an initial survey prepared by Meridian Associates. That survey was updated when we began work on the project. To the best of my knowledge and ability, this is an accurate representation of the site boundaries for the property. And again, our largest projecting bay does not encroach any closer at the closest point of 1/2 foot from the property line.
So to address that directly, there is a dispute. So what we did is we followed up with our surveyor and said, hey, take a look at what they're proposing. And can you comment specifically what they see as their claimed as the property line versus what the work that was originally done by this particular surveyor? Do you have his name, Barbara?
Yeah, Mr. Benson.
Yeah, what's his firm?
It's,
However, that opinion and or survey should have been sent in to us.
Well,
how-
hold on.
We have no way of knowing.
Right, that's the purpose of having these hearings and to get this.
Mr. Chairman,
Yeah,
on the letter that Ms. Joby sent in, she did attach a photocopy of that site plan, which is fairly clear, just for your knowledge and the board's knowledge. You should all have that, I believe.
Oh, okay, good. So in follow-up with our surveyor, they basically said, there seems to be a disagreement between what Meridian is saying and what our surveyor is saying. Our surveyor seems to indicate that he has the better argument, but he readily admits that there is potentially legitimate argument on both sides. And so the point is simply this: there's currently an unclear line that is not in agreement. And so if we use the existing structure as is and go out the full 2 feet, one way or another, it is either on the property line or so close that it's, potentially even over. The point is that the lines are so, the proposed structure is going to be so close to either line that it's unresolved. It will remain unresolved unless and until it goes through land court, and a land court, or however the process goes, to actually decide what that line truly is with finality. So all we're suggesting is consider it that if they say they're back by 6 inches, that might not be entirely true according to the documents that we have and the deed and the references and everything that we have, regardless of what Meridian or their survey is saying. And the point is it's unresolved. So to go directly on the property line or within a few inches one way or another seems to me to be opening up a can of worms.
okay, thank you. Anyone else wishing to speak in opposition?
I would
see,
like to- This is Barbara Job again. I would just like to say one more thing. When I talked to Dave Higgins, he said that they could push the window back to 18 inches instead of 2 feet, which would resolve the problem.
okay, thank
That
you.
would be the 6 inches.
Okay. Anyone else wishing to speak in opposition? I see Joanna Lou.
In opposition.
You need to unmute.
Are we good?
Yes.
Okay, I talked to Barbara
Hold
Job.
on. You need to give your name and address for the record.
Okay, my name
Remind everybody of that.
is David Higgins, 6 Dooley Street.
Hold on. Are you Joe? I recognize Joanna Lou. Is that your?
Joanna Lou is my wife.
Aren't you the applicant?
Yes.
You can't speak against your own project.
I don't want to speak against it. I just
Well,
want
you're not recognized at this point. There's a process that we have.
Okay, I just think we could.
Please, no. Please mute him, Allison. Anyone wishing to speak in opposition to the project? I see Joel Maxwell. If I could recognize, bring him in.
Hi, my name is Joel Maxwell. I live at 10 Dooley. My wife and I, we're not necessarily against the project. Excuse me. I have it's more of an environmental question. These two homes, are they on a sewer or are they on the step system? Because I know their if I remember correctly, their septic system is their driveway. And for my wife and I have lived here almost 20 years. And both of both the home that the residents in question here that's talking about modification and they've had tenants, they basically both have been, for the most part, vacant for 20 years. My concern is my question, I guess, is what is the long-term thought process for these two buildings? Because if the two of those buildings are going to start, like say, if they're going to retire there and then maybe Airbnb the other one, if their septic system if they have a septic system, will it hold whatever they're planning to do? Or are they on a step system like the rest of us? Because I know Barb Job, the direct neighbor, has had some runoff in the past, and that's my concern. And for her having to deal with it and us having to smell it.
Bill, do you have any feedback on that?
I can't say for sure whether these houses are tied in. I do know it's available in that area. I thought most people did tie in when they had the opportunity, but I can't tell you. I would assume that the engineers who are working on this project should know. And they should also know the location of that tank, which is not shown on the site plan.
Because you can't even, if you look even from if you go on like Google Maps, you can't even see not that it really means anything, but you can't even see the manhole cover, the cover for the step tank. That's my concern.
Well, they do show a sewer alarm box, which would indicate a step system.
Oh, okay. All right.
So I think that's the case there. Anyone else wishing to speak in opposition? Okay, now it's time for rebuttal. We'll recognize
This ought to be.
Mr. Luna?
I keep getting muted. With respect to the survey, all I can say is that the property has been reviewed twice by Meridian Associates. I don't feel that the plan is in dispute, but in an effort to compromise and projecting the bay back 18 inches is not going to architecturally be a significant change to the project, and that's something we can easily do.
Okay. Thank you. Discussion by the board?
Joe, so did the architect or the engineer who just spoke say they would consider going back to 18 inches? Is that what I just heard correctly?
Yes.
That is correct.
Please.
Okay.
It seems like that's the only point of dispute, Joe.
Yeah.
So I think if that compromise is put into the plan, from what I just heard, there is no more dispute from the neighbor.
All right, it's a straight alter and expand on the 1.9. So,
yep.
If we can condition it that it's that the bay window and any other extension is no greater than 18 inches. Anybody else? Any discussion?
Oh, it says lower hand.
Okay, then we'll entertain a motion.
Mr. Chairman, on the petition of David Higgins seeking a special permit under 1.9 to alter, expand a non-conforming structure to allow renovation of the existing structure at 6 Dudley Street. I do think that this proposed renovations I would move approval of the special permit with the condition that no protrusion from the building be any further than 18 inches off the existing structure. And I do think that, we do need to vote for the special permit because it is substantial. It does impact the nonconformity more than the existing nonconformity because they're protruding more into the sideline. But if they maintain it at the 18 inches, I feel comfortable that it's not substantially more detrimental than the existing nonconformity. So I move approval.
Second,
And I would ask that you both include in your motion and second, this will be subject to submission of a new plot plan showing the 18 inches and not the 24 that we would be able to stamp before the approval would be issued.
Yes, I would accept that alteration.
I would
Motion.
accept, I would accept it as my second as well.
Okay, motion made and seconded to approve a special permit under 1.9 with conditions. Roll call vote.
Ms. Pratt,
Yes, I would vote in favor for the special permit.
Mr. Nyman,
Yes,
Mr. Canavo,
Yes,
Ms. Slickty,
Yes.
Mr. Parisi.
Yes. You've heard our decisions favorable. We will need those, that amended site plan and be submitted to the building department. And I would ask Mr. Sanborn at that point to stamp it and sign it on behalf of the board. And we will need to write that, I guess.
Chairman Parisi?
Yes,
Yeah, when we submit our drawings for the final building permit, we can submit the modified site plan at that time. But we're actually going for the physical building permit.
no, because you won't be able to get a physical building.
All right, so you
permit
want to,
until
you want to
register
have,
this-
you
this
want to have
special
the,
permit.
you want to, just I want to be clear, you want to have the site plan modified now to show the projection of being 18 inches.
We have to, because we could not issue you the permit
Okay,
without it. You couldn't go your 20-day appeal and then register it at the registry of deeds. And until you've done all that, you're not getting a building permit. So-
okay, so we'll have Meridian Associates issue a new plan that shows the projection now back at 1.5 feet.
Yes, thank you.
Okay, thank you, and thank you for your approval.
Okay. Anybody want to write that one?
I'll write it, Mr. Chairman.
Ms. Schlichty, thank you. Okay, moving on to our next hearing is the petition of Michael Shimataro seeking a special permit, 2.3.1, number 3, 1 to 2 family conversion with exterior changes and variances. The lot area per dwelling, allow the construction of an addition of 26 foot by 32 foot with deck to allow conversion of 1 family to 2 family at 31 Magnolia Avenue. I believe Joe Taramina is representing.
Do we have Deb Ellison raising her hand? She may be taking his place.
All right.
I don't think. Yeah, I don't know. The application was with Joseph Taramina, architect. There he is.
He is raising his hand now.
Bring him in.
I believe Deb was taking over this case, Mr. Chairman.
Yeah, I wasn't notified. Attorney Ellison.
Thank you very much, Mr. Chairman. If I may share for the record, Deborah Ellison, Ellison Law Office, 63 Middle Street, Gloucester, Mass. And if I might share my screen.
Yes, please.
So the owner of the property is Michael and Lucia Shimataro, and they are on the call tonight. Michael's mother, Grace, and his father, Mercurio Shimataro, will live in the additional unit. The architect is Joe Taramino, and he is also on the call, and I believe you've allowed him in as a panelist. The engineer is John Judd from Gateway Consulting, and the property is located at 31 Magnolia Avenue. The Shimataros are seeking a special permit to convert a single-family home to a two-family with exterior dimensional changes. They are also seeking a lot area variance. The required lot area is 30,000 square feet and their lot is 12,732 square feet. And a variance for lot area per dwelling. Their lot area per dwelling is 6,366 square feet and they need 30,000 square feet. However, all of the other setbacks are met. The house is currently conforming and it will remain conforming. And they have submitted revised plans that show the entryway that connects the two units to be enclosed. The prior plan showed only a roof with an open deck. So it has now been enclosed so that it is under the legal definition of a two-family under the.
Right, yeah, that was my question.
Yes, and those plans were submitted.
Yep.
So the Shimataros, as I said, are seeking to convert their single-family home. The second unit will be for Michael's parents to live in. The parents have worked hard for their entire lives, and they'd like to, had some health issues in the last few years, and so they would like to have an opportunity to move into an affordable home and to limit their expenses and to be closer to their children as they age. The COVID has also changed their children's lives. Michael is working from home. His wife, who is a hairstylist, was out of work for 3 months, and they have 5-year-old twin girls. So the parents will be able to help with that childcare situation also. Their daughter also lives, Grace and Mercurio's daughter also lives 5 minutes away and has a young 7-year-old daughter. So this new living arrangement is going to work for all of them. They bought the house 4 years ago and did a lot of renovations, and they're not in a position to buy a two-family house somewhere else. They're really priced out of that market. So the house that is being built is very modest. It's 832 square feet. It has 1 bedroom, an office, a living room, and a kitchen. And from the back of the house, or the front of the house, you can see barely any of the new building will be shown. The property is also approximately 50 feet from the public way, so the addition will be almost hidden from there. Looking at the site plan, the lot is in the R30 zone and requires 30,000 square feet. This has 12,732 square feet. The existing structure is conforming and it's on a non-conforming lot. The setbacks are grandfathered to R10, so the front yard setback is 20 feet and it's compliant at 52.5 feet, and there'll be no change. The side yard setbacks are 10 feet and the right side is currently compliant at 20.6 feet, and it will remain compliant at 13.6 feet. The left side is currently compliant at 17.2 feet, and the proposed setback from the new deck will be compliant at 33.6 feet. The rear yard has to be 20 feet. It's compliant at 74.9 inches, and it will propose to be compliant at 37.3. The required frontage is 80 feet. It's compliant now at 90. Lot width is 100. It has 81 feet, but that will remain the same. Lot coverage allowed is 25%. Existing lot coverage is 9.8%, and it will remain compliant at 17.1%. So the Shimataros have spoken to many of the abutters. And let me see. They've spoken to the closest, this is their property in yellow. They've spoken to the people at 33 and 29. And the person at 33 has provided you with a letter of no objection. And the verbally, they have been told by the person who owns 29 that they don't have any objection. They've also provided you with letters from 19, 21, 28, 35, and 39. And they're not aware of any other objection to this project by any other neighbors. The special permit should be granted to convert from a single family to a two-family because the proposed use will not have adverse effects that will outweigh the beneficial effects, taking into consideration the neighborhood and the city. And it meets the criteria of 1.8.3. Social, economic, and community needs are met because this allows more affordable housing is needed in the city, and this is one way to accomplish that by converting single families to two families. In this case, it also allows the aging couple to live with in their own home with their family and to provide childcare for their children. Traffic flow and safety are not negatively affected. There's ample parking, and will not add significantly to the traffic in the area by adding one small unit. Utilities are adequate. The Board of Health has done a preliminary review of the septic system and determined that it has adequate capacity, and there's a letter that was submitted by the health agent. One additional unit will not significantly increase any other need for public services. It's also consistent with the neighborhood character. It's a residential neighborhood, and the additional unit will be added while still complying with all of the required setbacks and the lot coverage. It will not overburden the lot. Its location is toward the back of the lot, and it's behind the existing dwellings, and it will keep it mostly hidden from the public way. The quality of the natural environment will not be negatively affected because even though it's a small lot, it still meets the lot coverage requirements. And the septic system, again, will meet the needs of the two units. Potential fiscal impact is positive. Being a two-family, it will probably be assessed slightly higher than a single family, having a positive effect on the tax revenue. So I would suggest to you that it does meet the criteria of 1.8.3. With regard to a variance, the variances should be granted because strict enforcement would cause a substantial hardship created by the unique characteristics of this lot. There are large boulders in the back, as you can see. The septic system is in the front, so there really isn't any other place where this unit can be placed on the lot. The lot is also very narrow, and so it limits the area on the side where the unit can be placed. And this lot is a victim of a significant zoning change that caused the lot to become significantly undersized. It also requires that it have double the size of the lot for each unit, which this lot, of course, does not have. Despite that, it does meet all of the required dimensional setbacks, including lot coverage. With the rezoning, these lots went from R10 to R30, which is a significant jump in lot area, and it made a significant number of the lots non-conforming. So because of that significant jump in the zoning, this lot and these owners are not able to take advantage of the two-family use, which is allowed in most residential districts in the city. And financially, the Shimataros can't afford to purchase a two-family somewhere else. It's the only way they can provide a safe and comfortable home for their extended family. And so I would suggest also that it does not cause substantial harm to the public good because two families are allowed in most residential districts. And within the past couple of weeks, you may be aware the planning board has submitted a zoning amendment to the city council that would make it easier to permit accessory dwelling units. And although this isn't an AGU, granting the special permit and the requested variances are consistent with the city's desire to create more units for this very purpose of housing other family members. And as I said, again, all of the dimensions are setback dimensions are met. The closest neighbors do not have any objection. And for all of these reasons, I would suggest that the special permit and variances be granted. And as you know, Mr. Taramino is on the line if you have any specific questions about the project itself.
Thank you. Any questions by the board at this time? Hearing none, we'll go to public testimony. Can we take the screen down?
Yes.
Thank you. Anyone in the audience wishing to speak in favor of the project? If you'd raise your hand to be recognized. Anyone in favor? Remind everyone, if you're on the phone, you dial *9 to raise your hand. Okay, seeing none, anyone wishing to speak in opposition to the project? Anyone in opposition? Seeing none, there'll be no need for rebuttal. Discussion by the board? Anyone?
Well, I think it's I do think it's a good project. I mean, I'm happy it meets with all the setback requirements, and I don't think it's gonna adversely impact anybody, and get some more housing and multi-generational families together. I personally have no problem with it.
Yeah, I agree. I was concerned until we got the additional plans because it didn't really meet the definition of a two-family without sharing a vertical wall or horizontal wall. So, but I'm glad they fixed that. So we'll go to a motion then.
Mr. Chairman, let's see. On the petition of Michael Shimataro seeking a special permit to convert from a one to a two-family with exterior changes and variance for lot area and lot area per dwelling unit to allow for construction of a 26 by 32 foot addition with a deck. I would move approval on the special permit and on the variances. I think that Deb has laid out the 6 factors that it's met. I do think that overall it has more beneficial effects than negative effects. I think it complies with all the 6, taking into consideration the 6 factors. I think the variances also, that zoning change was really kind of a hardship placed on that lot in the sense that it has pre-existing with a home on the structure. But I feel like where they're complying with all the setback requirements and they're under the lot coverage maximum, I would vote in favor of the variances as well.
So we have a motion.
For the reasons stated, I would second for the special permit and for the variance.
Motion made and seconded for a special permit and variances at 31 Magnolia Ave. Roll call vote.
Mr. Nyman,
Yes for the special permit, yes for the requested variances.
Mr. Canavo,
Yes, for both.
Ms. Slichty,
Yes for the special permit, yes for the variances.
Ms. Pratt.
Yes, for both. I think it's a good project and I can definitely see the hardship.
Mr. Parisi.
Yes. I've heard our decisions favorable. If you'd prepare a draft for us, we'd appreciate that. And Mr. Sanborn, if you'd stamp and sign those plans on our behalf, would be much
Well,
appreciated.
if I can remind Deb, I do need a full-size set of plans, Deb, please.
Yes, we'll make sure you get those. Thank you very much. And I will draft the decision, Mr. Chairman.
Thank you. Okay, before we move on, did anyone not attend the hearing on 66 Eastern Avenue?
I did not.
Okay, so you will, James will be participating. James, were you at the previous one, 66?
What was the date?
February 20. It's the one that was near Niles Beach.
Yes.
You were here for that. Okay.
Yep.
Okay, so you'll be voting on this, and Catherine won't be.
Was I
Oh,
there,
yeah.
Joe? Mr. Chairman? Was I there that one? Was that the one I called out sick?
Allison, do you happen to have that minutes?
I don't believe so. It was just 2 meetings ago.
Okay,
Yeah, you were here.
okay.
Okay. So the next continued hearing is the petition of JCG Investments LLC seeking a special permit under 1.9 to alter and expand a non-conforming structure to allow the existing two-family to be demolished and replaced with new two-family dwelling at 66 Eastern Point Road. I'll make note that after the last hearing, we had there was some confusion about the status of what was there now. We'd asked the building inspector to do a little research, and it was determined that the home is existing as a two-family now, so it was re-advertised to be a conversion from a two-family demolished and replaced with a new two-family. So I will let Attorney Ellison take over from there.
Thank you very much, Mr. Chairman. Again, for the record, Deborah Ellison, Ellison Law Office, 63 Middle Street, Gloucester. The applicant and owner is JCG Investments LLC, and the manager, James Gattuso, is on the line tonight if we have any questions. The architect is Matthew Carlson from MR Carlson Designs. He unfortunately is unable to attend tonight. The engineer is John Judd of Gateway Consulting, and the property is located at 66 Eastern Point Road. Because of with the clarification of the issue of whether this is a two-family, it is a two-family staying a two-family. The special permit under GZO 1.9, 2.4.3, and 2.4.5 for the demolition, reconstruction, and alteration of a non-conforming structure on a conforming lot is what we are seeking for relief, and there's no other requested relief. As you recall, this is if I may share my screen again.
Sure.
As you may recall, this is a conforming lot, and it will correct two nonconformities, one in the front yard and then also a side yard. And the nonconformity along the rear yard is being improved all the way down the entire building. So the rear yard is currently non-compliant at 6.3 feet. It will remain non-compliant, but it will be improved to 9.3 feet. And that is the only remaining non-compliant dimension. Attorney Faraday mentioned at the last meeting, and Attorney Fine, I believe, pointed out in her recent opposition, that the 6.3 conformity is a little bit of a bump out, and that's correct. But if you look all the way down the building, the conformity is being improved. So it's slightly, but it certainly is being improved and is not any worse than it was previously. So the fact that it is merely a bump out where it's closest, that improvement continues all the way down the property line. As I stated previously, the building has been pushed back. You can see this is where it was originally. And now it's been pushed way back, which was a request of the owner of the property next door, Mr. Bordenaro. He asked that it be pushed back so that there would be less of an issue for him off of his front porch, which is here. There are also some other issues that were raised by Attorney Fine, and that has to do with the elevations. And I'll just address some of those. So she raises a question about whether or not this needs a special permit for height. We've thoroughly vetted that, and we don't believe that it does. This note, which says elevations are based on the top of slab at the exterior edge of the garage of Unit A. This is considered elevation 26 or 0 feet, 0 inches. That's the design elevation. So when an architect, and this is a confusing concept that I'm sure this board deals with all the time, but other people may not be familiar with. So an architect sets a certain elevation and they set that at 0, and that's how they do their design. However, the elevations for zoning are determined by the elevation from the average grade. So when you look at the average grade elevation, which was determined by the engineer to be an elevation 27, going up to the peak of the roof, it is at 29 feet, 11 1/4 inches. And that's for one of the units, but both units are under 30 feet. So the whole issue of whether this is within the height, we have no concerns about that. We don't believe that we need a special permit. As I said, it's been thoroughly vetted. The check on that is when we apply for building permits. If we're wrong in the calculations, the building department will make us come back to you for a special permit. But at this point, everything on the plan is consistent. There's been no manipulation of the plan. The average grade is what it is, and the building is under that average grade. With regard to the special permit to expand and alter a non-conforming structure, it should be granted if you determine that the new structure does not increase the non-conformity. because the new home is not substantially more detrimental to the neighborhood than the pre-existing non-conforming home. We will be more compliant than the existing home, removing the nonconformities of height and front yard. We did make some changes to the plan since the last time we were here. The dormers on both sides have been brought in by 3 feet to give it less of a boxy look. There has also been a change to the stairway on the right-hand unit so that it would make it less, the switchback has been removed. The trim has been changed to white trim. And you can see, even though the prior drawings included a 4/0 window, it was hard to see that in the renderings. But in these drawings, you can see that that is also a more colonial, traditional type look. And so this shows you the differences between the 3 units. You can see that the dormer has been brought in significantly from what it was before. And my client did that in order to allay some of the concerns of the neighbors. With regard to the issue that has been raised about the driveway, looking back at the site plan, I think you can see that no matter where this driveway is put, there's going to be an issue with the sight lines. And this is where the existing driveway is, so it makes sense that it stay there. If it were moved to this side on Eastern Point Boulevard, then it's much closer to the Bordenaro driveway, probably making it a much less safe situation. So all of those issues that have been raised are really not relevant to your decision. And we would ask that you look at the purposes of the special permit and the fact that there have been significant improvements in the location of this building on the site. The building, as I said, has been pulled back. Access will be in the same location. And a lot of the comments that you've received from the abutters are really to the design of the building, which is not the purpose of this board. The building is consistent in size with other buildings in this area. It's consistent with the building behind, which is one of the abutters that is opposing this project. It's consistent in size with many of the other units in this neighborhood. So I would suggest to you, Attorney Fine talks about it being a 51% increase in the size. There's nothing in our zoning ordinance that says that limits you to a certain percentage. There are some communities that have those types of ordinances, and we could certainly have that here, but we don't. What we have to control size is we have setbacks, and we have lot coverage, and we have height. And this meets all of them, except for the pre-existing condition, which is getting better. The permit to demolish and reconstruct the house has the same standards. And Attorney Fine suggests that 2.4.5D requires variance. However, that provision has been superseded by the Gale and the Diedrich cases. In the Gale case, which said that in this situation, only a special permit is required, that was a tear down. And that case was actually interpreting the Gloucester zoning ordinance. So I would suggest to you that a variance is not required under 2.4.5D. And those are, I don't want to go through everything, repeat everything that we talked about last time, but I felt it was important to address some of the issues that have been raised by the opposition. And I'm happy to answer any specific questions that the board might have.
Thank you. On the one, on the alter and expand, are you in agreement there's an increase in nonconformity, or no? Are you asking us as a 2-part test?
I think that there is somewhat an increase in nonconformity, so that you should look to whether or not it's detrimental to the neighborhood. I think that's the safest course to follow. I think there's an argument to be made it's not, but.
Yep, I agree. Thank you. Okay, we'll take any questions by the board this time. Any questions? You guys are quiet tonight. Okay, we'll go to, if we could take down the screen, we'll go to take public testimony. Anyone wishing to speak in favor of the application? Please raise your hand, be heard. Anyone in favor? Seeing none, is there anyone wishing to speak in opposition to the project? Joel Favaza.
Good evening. Would it be possible to be pulled in as a panelist to share my screen?
Can we do that, Allison? I don't know.
You should be all set, Joel.
There you go.
For the record, my name is Joel Favaza. I'm an attorney at Seaside Legal Solutions. I'm here on behalf of Tracy Dixon and Caleb Clapp from 1 Island Rock Lane. They are direct butters. Just gonna throw my screen up real quick for everybody. Everyone can see the screen. So, I don't want to keep everyone here all night. My clients are in opposition to this, and there's 4 basic layers of deficiency with this application. The first one is a lack of necessary information. As Attorney Allison just noted, the height calculations were challenged at the last hearing. In between that time and now, there's still no plan of record showing contour lines, identifying the spot elevations. There's a table on this plan that just kind of has some numerical calculations thrown out there. But if they're convinced they've shot the elevations properly and they've done the math, correctly, it's curious they won't just show us, their homework and, shut us up about this. So I think this board at minimum should require that you get out there and show you how they've decided to calculate this average grade. The second deficiency is that they're using the wrong section of the GZO. And so, as you know, section 2.4.3 is the alteration of non-conforming structure. And section 2.4.5 lets you use 243 for total reconstruction of a single or 2-family residence. And I think it's interesting that, Attorney Allison comes to you tonight, hoping to, rely on a memo from Bill Sanborn saying this is not a 3-family, but, they're telling on themselves in their own application. They're very clear that they knew this is a 3. If Angie Zakis was still alive and you dare to tell him that wasn't a 3-family, he'd talk your head off for a half an hour, explain to you exactly why there was a 3-family and why he did everything he needed to do to get that permit and keep that permit alive. And again, even if section 245 did apply, I disagree respectfully with Attorney Allison's view that these cases supersede this section. Again, it's very clear that if you're going to exceed or not comply with the dimensional requirements as part of your total rebuild, these are the dimensional nonconformities currently, and then this would be the dimensional nonconformity. Obviously, this section goes away. Section D is going to say you need to go get a variance, and so just respectfully disagree with Attorney Allison's contention that this is no longer applicable. And obviously, I think she will not disagree that this, even if her analysis is correct, it still only applies to a single and a 2-family, which I believe Attorney Fine or perhaps Attorney Faherty can explain to you better than I as to why this is in fact a 3-family still. But at the very base, the fourth and kind of most important reason why the applicant is not entitled to the relief they're requesting is that even if you take everything else they've told you as true, you say, you know what, the height is correct, we trust them on that. Section 245 does apply, and there's no need for a variance under 245 or under any of this case law. And the only standard that you have to weigh is whether or not this proposed rebuild is going to be substantially more detrimental. They still can't get the relief because over 60 neighbors in a couple dozen different properties have stated opposition to this project, and no one is in favor of this of record. One abutter was in favor last meeting until she had a chance to review the plans better, and it's my understanding that she has since rescinded her support and is now in opposition. These properties, property in red is the locus. The ones in orange are on the abutters list and are in stated opposition. Okay, every direct abutter is in opposition to this. Nearly everyone on the abutters list is in opposition to this. The majority of properties within 1,000-foot radius are in opposition to this. And there's widespread opposition. Every one of these yellow highlighted properties has at least one or more residents in opposition to this project. And so even if you, as a board member, are saying it's only this special permit standard, and you're a little torn as to whether or not this is substantially more detrimental to the neighborhood than what presently exists, I would just ask you to defer to the 60+ neighbors who are telling you this is going to be substantially more detrimental. And, don't superimpose, any ambivalence you might have over this overwhelming chorus of neighbors who are telling you this is the wrong project for this property. The last thing I'll end on is that I want to be very clear that my clients are not in opposition to this developer doing something, appropriate and doing something successful. And they truly do hope that something can be done on this property that works for everybody. Unfortunately, between last meeting and now, despite outreach from my client and others, there was no real ability to convince the applicant to sit down at the table and really discuss some issues, the virtual table via Zoom these days. And so despite that, kind of hesitance on the applicant's part, I want to be clear, my clients and I think several other neighbors would still be willing to work with them toward a solution that works for everybody. So you can flip all these orange and yellow oppositions into, positive support. And so I'll leave it at that. And thank you very much for the time.
Next up, in opposition, Meredith Fine.
Good evening. Can you hear me?
Yep.
Can you see me?
Nope.
Nope. Okay. Doesn't matter. First of all, obviously, I agree with Meredith Fine, 46 Middle Street. I continue to represent the trustees of the Seacroft condominium next door to this project. I want to just follow up on what Attorney Favazza was saying about the petitions. These petitions were not a matter of somebody pressing a button on a keyboard and signing on to an online petition. These folks went door to door. They did the hard work. They showed this plan to people, and there is just widespread discomfort with this proposal. And it goes beyond the immediate abutters, as Attorney Favazza was saying. The neighborhood is against this. And I know this is not a popularity contest. I know you have standards to weigh. But how many lawyers does a neighborhood have to hire to make the point that this will be substantially detrimental to the neighborhood?
Question. Are we in possession of some type of document that everybody signed? I don't have it.
It is available. Yeah. I'll let Allison answer it.
It was loaded onto the Google Drive.
When?
Tuesday.
Tuesday?
Yes.
So after the deadline.
After the deadline, everything gets loaded
So
on.
none of us look at anything after the
No,
deadline.
but they submitted it Monday morning.
I don't know. I've not seen it.
And well, it is on there. And if you need time to see them, I'd love for you to read the actual petition where 66 people say that this proposal will be substantially detrimental to the neighborhood, will be dangerous for traffic, and is overbuilding at a gateway location. The memorandum from the building commissioner, I'm sorry to say, relied on the wrong property. The decision that was cited as saying that this is two-family was actually for the Seacroft property and not for this property. But as I said in my second letter, this property has been three-family since at least 1966. It's been three-family on the assessor's cards. Nobody's ever challenged the assessment. You can't go back now and say it's two-family when it's always been assessed as a three-family. And as I said in my letter, the applicant purchased the property. It was advertised as three-family. This is a three-family, and it did not lose any of its zoning. It's been three-family at least since 1966. And that matters here because everything that Attorney Ellison is relying on does not apply to this application. The Dedrick and the Gale cases are for 1 and 2 family properties. The special permit that she's seeking is for 1 and 2 family property. This is a 3-family. It's been a 3-family for decades, and therefore it should not be entitled to get this particular special permit. The plan itself says that the building will be 31 feet. As Joel says, we can't look at the plan that's presented and draw conclusions about the height. We continue to believe that it requires a special permit for height. And Attorney Ellison's discussion about the mass of the building, that's the point of the substantially detrimental standard. That's the point of it. The point of zoning is to promote conformity, to protect neighborhood character. This is a neighborhood that is populated with buildings that look like a seaside village. This is a seaside village. When you look at the new houses at Daventry Lane, the duplexes, they fit in. They look like they are part of a seaside village. That's the point of zoning, is to promote conformity and consistency. How is it even possible? How is it even possible for a building to be this much bigger than what's there now and only need such a small amount of relief? It's not possible. It defies logic. It defies common sense. The neighborhood knows this building is too big. They know that it does not fit into the character of this neighborhood. And I urge you on behalf of the trustees to deny the application. Thank you.
Thank you. Michael Faherty. You need to unmute.
That better?
There we go.
Okay, my name is not,
Uh-oh.
Hello? You muted yourself again.
places now. Can you hear me now?
Yes, we can.
Okay, thank you. My name is Michael Faherty, and I represent Jim and Jan Bordenaro, who own property immediately adjacent to this parcel. I want to clarify something that was said at the last meeting and was raised again by Counselor this evening. It's represented that my client somehow endorsed this project or had conversations about the design with the owner. That is categorically not true. The conversations focused on an initial situation where my client was asked about whether he would have a problem with the applicant putting a driveway in the basic location where his driveway is to his lot. And he was told by my client that he didn't have anything to do with it, but he didn't think the city would be too impressed with that location. That was it. Further, he was asked at one point by the owner, what do you think of the design? And he said, I haven't seen any plans. And he saw the plans just like everyone else late in the game. Now, I'm going to challenge Mr. Sanborn's memo. And in fairness to Mr. Sanborn, I'm going to publicly tell Bill that I attempted to reach him. There were phone problems at the office and we weren't able to connect. But in any event, if you look at Bill's memo, the reference to the January 27th, 1983 decision, that related to property at the adjacent property. And you might ask, how do I know? I was the attorney for the petitioners in that application. And it was very clear, and it's on, if you look at the decision that's referenced, my name as the petitioner is there. And the argument that I raised at that point was there. So unfortunately, that particular decision dated January 27th, 1983, cannot really form the basis of a decision that's made by Mr. Sanborn. Now, the second point is that unless Mr. Sanborn has personal knowledge of the condition of the Zakis property in 1985, I don't think he can testify or even offer the other example as evidence. He's relying on a parenthetical clause that's in the heading on the decision. And that parenthetical clause says that there be no additional dwelling units. I would suggest to you that the parenthetical clause with no definition, no place else in the application except in the decision is it referenced, can be interpreted alternatively just as powerfully. First of all, there were 3 units in that building. And the notion that there be no additional units presupposed that there would have been, the units in the building would have been made larger, and one of them would have been put above the garage. Now, as we know, that garage wasn't built. But I say that there's an alternative interpretation of that clause that's just as viable as the interpretation that Bill gave it, okay? The next point is that about the 3-family. Even in the long train of the Zakis' property ownership here, there's a municipal lien certificate from 2008 where it's labeled, the city is characterizing this as a 3-family. In addition to that, there's also the current city records, the assessor's property card listed as a 3-family dwelling. And I think most importantly, if it's already been pointed out that the application defines the property as a 3-family, but moreover, the applicant himself, there's no apparent record of the applicant after he bought the property in August of last year, making any application to the assessors or any other person in the city to change it from a 3 to a 2. That's telling. Now, if there is an application pending, then I would withdraw that argument, but I'm not aware of that. So you can't have it both ways. And I think that you're compelled to, treat it as a 3 because the applicants treat it as a 3. The applicant made an application as a 3, and it doesn't seem appropriate to suddenly say, no, that's a 2. We start doing that, then we're putting characterizations on property that go far beyond your jurisdiction. You're allowed to hear cases, decide cases, but I don't think you're in a position to accept or make rulings on whether they're 1-family, 2-family, etc. The last point I want to make is that I don't see how section 2.45D, subsection D, could be any more clear. It says absent a variance, period. And I don't agree with the statements made by counsel for the petitioner that somehow or other decisions that are made in the Supreme Judicial Court or the Appeals Court, I think they were both Appeals Court cases, nothing's changed in our ordinance. If the ordinance was going to be changed, it would have been changed. These are cases that were decided on the facts in that case. That's it. And no one has taken any time to change the Gloucester ordinance. So today, when you're deliberating, you have to go by the plain meaning of that ordinance. And it says, absent a Board of Appeal, a variance, you have to make sure that the expansion of the property conforms to all of the requirements. And it says, especially with respect to dimensional relationships. What that means in this case is simply this. The applicant either needs to apply for a variance from the 20-foot rear yard requirement, or they have to move the building. It's as simple as that. And there's talk here about how the building doesn't fit anyplace else. Well, it comes in within the rubric of the things that always happen. The building's too big. Of course it doesn't fit in a lot of other places. But that doesn't mean that, because someone says this is what I need, that suddenly becomes the standard for this. You need the variance. Absent that, there's going to be problems. And I just don't understand why it's even been allowed to come this far. Thank you very much.
Thank you. Next up, in opposition, Caleb.
Hi, zoning board and chairman. I am the person who delivered the 66.
Name and address, please, for the record.
Yes, Caleb Clapp at 1 Island Rock Lane, directly across from the property. And I just wanted to certify verbally to you in person, virtually, that I dropped off the 66 signed statements of opposition to the Zoning Board of Appeals office on Monday at approximately 11 a.m. And they were received by a woman who took them and said, yes, thank you. These will become part of the record. And I verified that they were submitted on time, and she confirmed that they were. And it is a 1-paragraph statement, which I will read to you, which says, in each case signed individually by individual people, we, the undersigned, oppose the building proposed for 66 Eastern Point Road. The building is too large, will create an unsafe traffic hazard, and will be substantially more detrimental to the neighborhood than the current building. The property is a gateway to Niles Beach and must be protected from overbuilding. And 66 neighbors separately signed that and submitted it on time to the ZBA. And I would hope that it's in your files. Thank you.
Thank you. Anyone else wishing to speak in opposition? Please raise your hand. Seeing none, we'll close the public. Oh, hold on. Mary Ann Boucher.
Hi, Mary Ann Boucher, 93 Mount Pleasant Avenue, and my husband Stephen Boucher and I own 75 Eastern Point Road, which sits almost directly across from the Seacroft condominiums. I actually spoke in favor of this a couple of weeks ago, but I was given some incorrect information prior to the meeting. So as Joel Favaza indicated, the neighbor that rescinded was me. And I do have concerns about the building. Sitting in front of my house, it is not uncommon to see bicyclists, large trucks, and automobiles coming around that corner at a high rate of speed. Bicyclists almost being hit on that corner. It's very, as you all know, it's an extremely busy corner, especially in the summer, every weekend, all year long. I know that Angie had a hard time getting in and out of that driveway. I know that it was a 3-family prior to whatever's going on now. And I'm highly concerned about that building coming out further than what it is. I'm highly concerned about the cars that'll be coming in and out of that driveway. And the other development that just took place, those houses are all off the street and they fit the neighborhood beautifully. And I am concerned, so I just want it to go on record that I am rescinding my position as in favor to opposition after reviewing many more detailed reviews of the property. So thank you.
Thank you. Okay. Anyone else in opposition? We're going to, seeing none, we're going to go to rebuttal. Attorney Ellis.
Thank you, Mr. Chairman. First of all, with regard to the height, the applicant has submitted all of the information that this board requires to be submitted. There is a calculation on the plans from the engineer that determines what the elevation is. And there are stamp plans from the architect that show what the what the height is over the average grade. So again, that's not something for this board to determine whether or not the applicant needs another permit. The applicant is thoroughly vetted that issue, certainly looked at it again when it was raised, and there's absolutely no concern with the height of this building. There's no need for a special permit for height. If I might share my screen again, Mr. Chairman.
Yes, please.
So with regard to, with regard to the issue of the three-family, again, that's a decision for the building inspector to address. But we did look at that further, and I do agree with Attorney Fine, Attorney Faraday, that the 1983 decision was a decision that was related to the building that is owned by the clients of Attorney Fine, the big duplex that is behind us. And so at the time that application in 1985 was for the variances, it was a three-family. So we had one in here. I'm not sure how it was done, but over here there was a unit. And so in 1986, and so this is the unit today. So you can see that it's missing. So this part was there and this unit was torn down, this third unit. That was done in 1986. This is the assessor's record that shows this piece gone in 1986. And so after that time, Mr. Zakis went at certain points to obtain building permits. And at some point he put up a foundation. And so 35 years ago, this piece here was removed. And up until around 2004, he kept seeking extensions of building permits and obtaining extensions of building permits. And that's about 17 years ago. Since that time, there hasn't been any further activity. The unit for 35 years has not been used as a three-family, and it was never constructed. It still looks like it did back in 2004 or earlier, 17 years ago. Now, if I had come in here with Mr. Gattuso and said to you, this is a three-family, we want to build a three-family, I think you would have looked at me, after 35 years of this use not being a use, you would have said to me, counsel, how can you say after 35 years that this is a three-family when the use has not been used as a three-family? Having a foundation doesn't make it a three-family. The variances that were requested did not go to the fact or the issue of whether or not the three-family was allowed. There was no permit granted for the three-family because it was already a three-family. So I would suggest to you that the building inspector is correct after looking at further information, and that a use that has been fallow for at a minimum 17 years with no activity and no desire or intent to convert it back to a 3-family, that despite what the assessor's records say, they don't change their records unless someone comes in to contest it.
Correct.
Or unless a building permit is issued. So I would suggest to you that it's the building inspector's determination, and the building inspector has stated that it is a 2-family, and that's what we're going forward on. With regard to 2.4.5, when there are court cases that interpret ordinances and interpret certain factual situations, they apply. It doesn't mean that the city or town is going to go ahead and change their zoning ordinance. They very often don't. And in this case, the Gale case were exact same situation. It was a tear down, and the court was looking at whether or not it needed to have a variance, and the court said no. And the court had all of the ordinance of the city of Gloucester in front of it. And the court could have said, well, the city can do something that's different than the state law, but it didn't say that. So I think that the 2.4.5 is inconsistent with the case law and the recent different iterations of that, and that this only needs a special permit. And it's not something that this board is in a position to really decide. If the abutters decide to appeal, of course, they would have that option for a court to address that issue. And with regard to the neighbors, the petition talks about overbuilding. Again, when you look at the request that we're making, it is a 2-family. It is not we're not talking 5, 6, 7 units on this lot. We're talking a 2-family with livable space that's consistent with all of the other buildings in this vicinity. They all range from 2,000 to 3,000 square feet livable space. So it's very similar to that. It meets all of the zoning requirements, all of the setback requirements, other than the one that is existing. And so Attorney Faherty says we want it pushed back away from this building. Well, it's not pushed back away from there now. And that's what the court says. It looks at that issue and it said that you could, in fact, build right up to the line. But my client didn't do that. My client actually improved it a bit. And with regard to the number of neighbors, I think it was Attorney Fine that said she understands it's not a popularity contest, and it isn't. And in the most recent case that the city had, Espresso's restaurant, the court was very clear that it is not necessarily the number of neighbors who agree or disagree with the project. It comes down to whether or not it is more substantially detrimental to the neighborhood, given the changes in the setback and the changes in the dimensions, which here, as I said, have been improved. To go away, the height exception goes away, the front yard variance goes away, and we just have one remaining. So I would suggest to you that this is not a project that merits this kind of consideration. It is a modest project and certainly in keeping with the neighborhood, and, you know, very similar in style. Well, no, it's not really similar in style to that. But if you have any other questions, I'd be very happy to answer them.
Thank you. Okay, if we could take that down.
Yes.
And discussion by the board.
Joe, what's the current square footage opposed to the proposed square footage? Does Attorney Allison know that?
Are you the footprint? Or,
Yeah, or square footage of living space.
Yeah, two different things, but yeah. I'm
All
sure
right.
she has that.
I don't think I have the existing living space. I'm not sure I have that information. I think, let me see. Unfortunately, as I said, the architect is not on. He had a family issue that he had to deal with. The proposed building footprint is 2,541 square feet. I'm gonna pull this back up.
Yeah, you had that one drawing where,
Yeah, I have the drawing. I was just wondering what the living square footage was.
I'm not certain, and I don't think it shows on there. If I could have a moment, I could ask my client if he has that information.
sure.
Oh, perhaps, actually, it might be on one of these. I apologize, I'm not finding the information.
That's all right.
I apologize.
Just trying to get a comparison to the size of the building and.
It certainly increased in size, you know.
Sure.
And,
Yeah, overall, I think on the footprint, you increase a little in the back, but you save, some comes out on the front right.
right.
So I think overall footprint, it may be a little bit bigger, but not,
Right.
Right.
but it is, you know, multi-floor.
Yeah, I'm looking at the red outline. It's not too crazy. Yeah.
Yeah, I think the issue with livable space that's a little is a little bit difficult to look at is that if you have a finished basement, you know, you have more livable space than the same house that doesn't have a finished basement, you know, so it's not always an accurate determination of size.
I see James had his hand up. Was he
Yes,
answer your question?
perhaps.
Let's see if Allison, if we could hear him. James Suso, the owner. James? James, can you hear us? Are you there? Not getting anything from him.
So online assessors shows the existing at around 2,800 square feet livable space. So my best guess is that this house is going to be about twice the size livable space of that one. That would be my guess. If the footprint's 2,500 square feet and there's 2.5 stories, it's got to be approaching 6,000 square feet. I mean, I don't know. If they don't know, then
Right.
I can't know definitely, but I'm just sort of doing a little bit of math, and that's sort of where I'm coming. You know, 5,500 to 6,000 square feet.
Hello?
Yes, James. Are you there?
Yes, I'm here, sir.
Do you have footage information to share?
Yeah, so the footprint of the house is around 2,000 to 2,100 square feet per unit. And each unit is around that 2,000 square feet mark. So I would say it's closer to the 4,000 or 4,100 square feet, first and second floor living space.
That's the new property, the new home.
Yes, that's correct, sir. And those ratios, we worked really hard to be well below the gross floor ratio area, not utilizing the full lot coverage area of the lot. So we tried to keep the square footage as minimal as we possibly could.
Okay, thank you.
You're welcome. Can I just say something else for the record too?
Is it off this subject?
No, it's on the same topic. So that, the site has a pretty substantial amount of topography issues with pretty defined ledge and green rock outcroppings. And there's a substantial amount of outcroppings underneath the current building. But it's a challenging site with, a bit of ledge and a bit of rock and,
Yeah, again, those are not,
sorry.
there's no variance application, so that's not a factor.
Yeah, fine. Thank you. Thank you.
Any other questions by the board, discussion by the board?
Yeah, I think the issue, it's not an easy one. That's the issue for me. That are we taking the merits that this is a two-family tear down to a two-family rebuild? Is that ultimately where we're falling in our decision? I mean, that's been seriously challenged. That one of the things that Bill, depended on has been accepted by the applicant as inaccurate, for instance. So I just want to make sure that that's how we want to move forward, that this is a existing two-family tear down. So we're at special permit, tear down, rebuild. Is it more non-conforming? Is it substantially more detrimental to the neighborhood? I think that's what we're asking, right? If that's the track that we're on.
Right, I agree. The substantially more detrimental is definitely, that's what we're on the board for, to just see what we think is substantially more detrimental. 66 people signed a petition, but nobody stated why they thought it was more detrimental. And none of the people testifying gave any, to me anyway, reason that it would be considered substantially more detrimental. I don't know what the detriment is. But again, we're back to, is it a 2-2? And if it's a 3-2,
it's a whole different animal. Yeah.
The variance comes into play on the right side.
It does.
The rear, or whatever.
So it's not advertised properly. It's not,
Oh, it was re-advertised. Yeah, it was advertised as 3-2. It's re-advertised 2-2.
Yeah.
After the information. I guess we could ask Bill if he has any more he wants to add to that.
I will try to clear this up a little bit if I may. After Attorney Fine sent out her letter, I did some more research on this property, and I have found out it is true that the document that I used was in our folder. At one time, those properties were owned by the same person and files were mixed up. However, I went back looking, and it's true, this building has been a 3-family. It goes way back, as far back as the house is there. There's the 2 units that were added onto the side and were rented out as summer cottages for quite a history of time. Back when he went to the zoning board to get the permit, the special permit that was to keep the same amount of dwellings, the house at that time was a 3-family. I verified through our records, through the assessors, what they have. It was definitely a 3-family. When I further look at the assessors, we found that, and excuse me on the dates, I don't have them all exactly in front of me, but he applied for the variance, was granted the variance. Shortly after that, he took out a building permit to tear off the 3rd cottage. He removed that completely and installed the foundation. At that time, he stopped working on it. He kept asking for extensions, and extensions were granted up through 2004. Which means in 2004, the last time he was granted an extension, that would have ran for 6 months. Building permit's good for 6 months unless you ask for an extension. Since 2004, he has not asked for any extensions, he being the previous property owner, and none were granted, and no work whatsoever has been done to that house. Therefore, in its present condition, it's being used as a two-family, and it has been since 2004 or earlier, since he tore off the addition. So I may have used a little wrong judgment on making my first decision, but when I went back and did the history again, I still believe that he abandoned his three-family when he failed to ask for extensions and keep his permit up, and he abandoned the use, and therefore at that time it became a two-family. The assessors will assess you for what they get building permits for, not what was built. So if you take a building permit out to change the use of your house and never do, the assessors will charge you for what that building permit says until they find some other document that changes their opinion. Just for instance, today we dealt with one there from a letter from Jimbo Valley back in 2012 or 2, I believe it was, where the board determined that a house was already a two-family. That letter was not accepted by the assessors, and therefore we had to today make that lady apply for a new building permit to change her use so she can get the proper use of her house. Just an instance of how it works. Without a building permit, they will not change the use, or without some type of letter given a reason from me. Again, everybody raises this question as to whether this is a two-family or a three-family. The board at the last meeting had asked me, our ordinance and allows for the board to reach out to any city department and request information from them in order to make your decision. So asking me the legal use of the building is definitely among the rights of this board to gather information, and you've done so. If somebody doesn't like my interpretation, there is a route to take that. Fortunately or unfortunately, however anybody wants to see it, I am charged with determining what the legal use of every property in the city is. And I've made a decision. I may use some wrong information in my memo, but I went and further checked to see if I was still correct, and I believe I am still correct, and the use of that building is a two-family.
Thank you. Adria, any thoughts?
I'm having a tough time with this. I first was, of course, thinking exactly the way Michael was, in that it's not up to us to determine the use of this property. And so until that's done, we can't really make a decision. Now Bill has cleared that up, and his position is that it's a two-family. Obviously, a special permit is granting that is a lot easier than a variance. I'm just having a lot of trouble with all of the opposition. And I know the standards for a special permit aren't as strict as the variances. I don't know. I think don't know. I think I'd like to hear more from the board and what people are thinking. I'm having a tough time with it. I know design is not something we deal with, but I see the issues that the neighbors are bringing up. So I don't know. I'd like to hear more, I think, before I can really decide.
Okay. I do know, I mean, the question raised about the height calculation, we're not here to challenge every licensed engineer's paper that he puts before us. And that could be required to be documented at the end of the project. We've seen that with the appeal up on Wheeler Street, where the people got their survey, GIS survey, and it proved that they hadn't gone over the height. So that's something for down the road. I don't think that's ours. None of us are in any position to argue with a stamped engineer plan. So I think that's off the table. And again, I think the 2-2 and the 2.4.5 makes sense. I also think the Diedrich case the other case and Diedrich both come in to play. We've seen these extensions of these non-conforming lines all the way down the length of a property, which we've never been happy about, but it is case law, and we've had to accept that. So the real issue comes to the determination, is it substantially more detrimental? And again, I say substantially more detrimental to the neighborhood. And I think that's really this thing we're talking
Yes,
about.
I think some of the stuff that I heard isn't valid. So, I mean, for me personally, this isn't my favorite looking house. I'm not the house police. It sort of made that determination. I've been on the board, 12 years now. I mean, there's lots of buildings that aren't my favorite buildings necessarily. And yet I don't feel like I'm the beauty police. I've heard concerns about, safety. It's a two-family house. I don't feel like it's my job to decide, where that driveway goes per se. It's always been a two-family house. It seems to me it's been as dangerous as it's ever been. So that just doesn't feel like a valid argument. It's the gateway to Niles Beach. I think that's true. It's a seaside community. I think that's true. I probably would design a different house. But some of that's my own aesthetic taste. So I'm not sure that the neighbors get to, in fact, I am sure that the neighbors don't get to choose the aesthetics of a building. So I think that should not be considered in what is substantially more detrimental to a neighborhood, the color or the shape or the style. Sorry, the neighbors don't get to choose that. I don't want them to choose that for my house, and I don't feel like they get to choose it for this house.
Okay. Peter, anything?
I definitely agree with Michael. I know the neighbors are making a lot of complaints about traffic and the safety, and I completely understand. I live on 133. I know everything about backing up on a high traffic lane. However, like Bill stated, it's always been a two-family, at least since 2004, when that extension expired. But how many cars are they gonna, you know what I mean? They're just gonna back out the same amount of cars that I think that were already existing. It's not like a 6-unit building going in there and they're trying to cram a car for each unit. At best they might have 2 cars per unit. And if it was treated like that for all these years, I mean, other than the building being bigger, I don't see the safety really being an issue, as well as the whole project. I mean, just looking at it from the outside, yes, it's a big building on a lot, but it meets everything that it needs to meet. So who am I to say different? Like Michael said, I don't always like the project or the aesthetics or whatnot, but I mean, that's a tough decision.
Thank you. James, any questions or comments at this point?
I'm with Michael and Peter on this one. If it's determined, as Bill has determined for us, that it's a 2-2, I mean, I'm with Mike and Pete in agreement that it's, the traffic pattern's not going to change. We can't pick what the house looks like. So I'm on the, I'm, it's a tough decision, but I'm with Mike and Pete on this one.
All righty. Anybody else? Any last comments? Adria? No? Okay. So we'll need to have a motion on the application. Michael, could you?
I can make a motion. Yep. Petition of JCG Investments LLC seeking special permit 1.9, alter, expand a non-conforming structure to allow the existing 2-family demolished and replace with a new 2-family dwelling. I'd make a motion that it is more non-conforming. I think it is substantially larger by probably at least 30 or 40% than the existing building. And I do not believe my motion would be that it's not substantially more detrimental to the neighborhood.
So there were 2 special permits, right, that we're approving?
Yes.
Also an expand and the 2.4.5 conversion.
Yes.
And again, they have the same standards. So could you make that as part of your motion, the second part?
Yes. that for 2.4.3 and 2.4.5, 2.4.3, and for special permit for the change, extension, reconstruction, or alteration of a pre-existing non-conforming use or structure. So that I believe that it's not substantially more detrimental to the neighborhood than the existing non-conforming use or structure. And then the second one is 2.4.5, demolition replacement of a pre-existing non-conforming single or two-family residence. And again, so the standard, and you have to, it's got to be include the complete demolition of the structure and the construction of replacement structure. But I don't believe that it's substantially more detrimental to the neighborhood.
Okay, motion made on the two special permits. We need a second.
I'll second that.
Made and seconded on the petition for 66 Eastern Avenue to grant two special permits, one under 1.9 and a special permit demolition and replacement, two-family, 2.4.5. Roll call vote.
Mr. Canavo,
Yes, in favor of both.
Mr. Gelati,
Yes, in favor of both.
Ms. Pratt,
Yes, I think I have to vote in favor. I don't love the project, but I think that's not up for me to judge. So I'll vote in favor.
Mr. Nyman,
Yes, I'm going to vote yes on both special permits.
and Mr. Parisi.
I vote yes on both special permits. I feel it is an increase in nonconformity, but not more substantially detrimental to the neighborhood. And I believe it meets the same standard for the demolition and conversion with the conditions that apply to that section of the audience for the, the pace of construction and all that be followed and be part of the decision. The vote is favorable. You've heard our decision. We would request a draft, and Bill, if you would stamp and sign those plans on behalf of the board, that would be appreciated.
Thank you very much, Mr. Chairman. I will do a draft, and Bill again will get you the revised, slightly revised plans.
Yes, thank you. Full size. Thank you.
Yes.
Thank you. Our next hearing is the petition of Fuller Schoolhouse Road, Inc., seeking a variance under 4.3 sign ordinance, relief from total signage to allow signage to be added to the new YMCA at 7 Gloucester Crossing Road. Must be Chris Lubasco.
Actually, Mr. Chairman, I'm handling this one also.
Alrighty, Attorney Ellison.
Okay. Again, for the record, Deborah Ellison, Ellison Law Office, 63 Middle Street, Gloucester. And as you said, this is for the YMCA of the North Shore at the Fuller School. The sign designer installer is Metro Sign and Awning, and Mr. Mark Conserva is on the line, and I would ask that he be brought in. He'll explain the signage. And this property is located at 7 Gloucester Crossing Road. We are requesting relief from the sign ordinance 4.3.2 subsection 1A and seeking a variance to allow 4 additional illuminated wall signs. 4.3.21B, a variance to allow 150.01 square feet of additional sign area. And 4.3.23A, a variance to allow the illuminated signs to each have a square footage greater than 12 square feet. And I'll share my screen so that we can show the signage. So the YMCA is seeking signage in addition to what is allowed under the ordinance and larger than what is allowed under the ordinance. The hearing was continued because there was a question as to whether this board had jurisdiction. And so I reviewed the mixed use overlay district ordinance and talked to the building inspector about it. And you can see from the last sentence, it states that nothing in the MUOD shall restrict the rights of any owner who elects to utilize the existing underlying zoning district regulations to develop or redevelop land. So in essence, the ordinance gives an applicant the right to either use the underlying uh, ordinance, which would be here going for a variance to the ZBA, or to seek a special permit from the city council. And typically you would do the city council route if you had other city council ordinances or variances, excuse me, special permits that were required. So we do believe that this is proper jurisdiction. And so what I would like to do now is ask Mr. Conserva to explain the requested signs and the variances, if he's been brought in.
You can't tell the screen up, but
Oh, do you want me to put it down?
well, Allison might be able to.
I would speak, but I did not completely bring him in until you gave me permission to.
See on the cell phone?
Is there?
There he is.
Hello?
Yeah.
Hello.
Yes. My name's Mark Conserva with Metro Sign and Awning in Tewksbury, 170 Lorem Street. I'd just like to read for the record the narrative I've prepared. The new Glenn T. McLeod YMCA rises at the entrance of Gloucester Crossing Road as it leads into the vast commercial and residential uses presently under construction in the Gloucester Crossing development. Due to the generosity of many, the impressively designed structure is massive and will be home to innumerable and varied civic spaces uses for the citizens of Gloucester, Cape Ann, and beyond. Within the single building will be the Lindsay and Beth Coolidge Gymnasium, the Burns Family Education Center, function spaces, meeting rooms, dining facilities, and a myriad of spaces to serve the public and private sectors of the region. The YMCA is a nonprofit organization, and the creation of its new home is due to the generosity and philanthropic gestures of many, several of whom will be acknowledged by the naming of particular spaces within and without the building. Portions of the proposed signage will address this responsibility. The topography of the land slopes significantly from south to north, running below and away from Gloucester Crossing Road. This sloping has determined the siting of the building and its infrastructure, such as access roads, driveways, and parking lots. Identification and directory signage is necessary to direct the public and other users to safely and efficiently locate the parking and building entrances. Zoning of the parcel is EB, extensive business. The pertinent ordinances relating to signage in the Gloucester zoning bylaws is section 4.3.2, regulations applicable to signs in non-residential districts, and more particularly subsection 1.a, which restricts the total number of wall signs to 1, and subsection 1.b, which restricts the maximum area of total signage on a parcel to 60 square feet. Subsection 6.a also restricts the square footage for an illuminated sign, wall sign, to a maximum of 12 square feet. As proposed, there are 4 internally illuminated signs which exceed 12 square feet. Location number 1, the letter set over the front entry, measures 24 square feet. Location 2, the logo and letter set on the entry side of the building measures 37.13 square feet. Location number 3, the logo and letter set on the east elevation measures 44 square feet. In location 4, the logo set on the south elevation measures 44 square feet. The elevation of the building below street level, the necessity of orienting the building's entrances at the rear of the parcel, along with the massive size of the structure, creates a significant hardship on the property and its designers to conform to the general purpose of the sign regulations, which are to provide for a wide range of signage by right, to encourage safe, effective, informative signage, to protect property values, and to minimize the visual impact of signage. Strict compliance to the ordinance, in this case, under these circumstances, demands and requires relief from the ordinance in order to meet the ordinance's specified goals. Economic, social, and community needs will be served by the proposed signage. The proposed signage will enhance traffic flow and safety for all concerned. Utilities will not be negatively impacted by this proposal. There will be no negative impact on the character of the neighborhood or its social structure. And finish up. The proposed signage will not negatively affect the environment to include buffer zones and wetlands. The property values within Gloucester Crossing development will not be impacted by the relief sought. I believe Deb has some slides here, as I'm going to do a better description of the signage very quickly. But I would like to tell the board that they should have this paper in front of them as well, and the dimensions on location 2, 3, and 4, the square footage changed due to a installation situation where originally the signs were going to be placed directly against the facade, and due to the like I said, the installation and electrical situation, a backup panel had to be installed. And the backup panel is reflected on the drawings and within the square footage mentioned in the narrative, but does not agree with the paper you have in front of you. What I will read, and when I read this paper, I'll read the correct dimensions. Location 1, the main ID wall sign over the front entrance on the north facade of the building facing the parking lot. The dimensions, 13.75 inches in height by 22.75 inches in width by 1.5 inch in diameter equals 24 square feet. The material is stainless steel. The illumination is internal LED halo lit. The color is black, and the copy is the Glenn T. McLeod YMCA. Location 2, the channel letter and logo set on the backup panel on the north facade of the building facing the parking lot. The dimensions, 66 inches in height by 81 inches width by 1.5 inch depth equals 37.13 square feet. The material is stainless steel. The illumination is internal LED halo lit. Color is black, and the copy is the logo YMCA. Location 3, channel letter and logo set on the east elevation of the building. The dimensions, 72 inches in height by 88 inches in width by 1.5 inch in depth equals 44 square feet. Once again, the material for all these letter sets is stainless steel, and illumination is internal LED halo lit. The color is black, and the copy is the logo YMCA. And location number 4 is the same exact dimensions as location number 3, and that is on the south elevation of the building. I'd be glad to answer any questions or concerns.
So while the sign's going to be on timers, because the regulation does require restricted hours.
That can be done if at your request, absolutely.
Well, that's the ordinance requirement on internally illuminated.
I understand
They're
that.
tied to the hours of operation or not later than. I don't have the detail in front of me, but it will be part of the
Yes, I believe it's
decision and
11.
limitation.
I believe it's 11 to 6.
Yeah, they will comply with all of the requirements in the ordinance with regard to the illuminated signs.
Yep. Okay. Anything else, Attorney Ellison?
The only thing I just want to point out is that you are probably familiar with the building, and you can see how it's set down from the road so that it is necessary to have signs at different locations. It's also at the rear of the lot with several different uses on that property. So making it simple and easy for people to find it is the intention.
Okay, any questions by the board or anything at this point? I mean, I would just like to say, I think our sign ordinance was written with Main Street in mind. You know, we've been building these large buildings. We did this up at the marijuana facility in Blackburn Industrial Park. And certainly a majestic new building like the YMCA deserves signage that will serve the public directionally and what they're trying to do. So I think it's certainly something for us to consider, but we'll go through the process. I'd like to have public testimony. Anyone in the audience wishing to speak in favor of the application, please raise your hand. I see none. Anyone in opposition to the signage to this application? Anyone in opposition, please raise your hand.
Mr. Chairman, there was Mark C. had his hand up.
That's the gentleman that presented.
Oh, I'm sorry. I
Yep.
thought it was him.
Sorry about that.
Anyone in opposition? Seeing none, there'd be no reason for a rebuttal. Any other discussion by the board, or we good to roll?
I'll make a motion, Mr. Chairman.
Sure,
On
go
the,
ahead.
if everyone's ready for one.
Yep.
On the petition of Fuller Schoolhouse Road, Inc.
Excuse me 1 minute. I had Kathleen as absent for the last hearing on this.
I'm sorry, I didn't realize there was a presentation prior.
I don't know if there was. That's
No,
what
there
I'm.
wasn't. There wasn't.
wasn't.
We, it
There
wasn't,
was no
it
presentation.
was
no.
withdrawn, yeah.
Oh, excellent, thank you.
Yep, go ahead,
Okay,
Kathy.
but thank you, Bill. On the petition of Fuller Schoolhouse Road, Inc., seeking variances under 4.3 sign ordinance for relief from total number of signs and total amount of signage. I move approval of the three variant, is it three, Deb? 3 variances requested.
Yes, it's 3 variances.
I'll second that.
Motion made and seconded with 3 variances. Roll call vote.
Ms. Swifty,
Yes. On all 3 variances.
Me?
sorry, Ms.
Did you say
Pratt?
me, Bill?
No,
Oh,
Ms. Pratt,
yes, I would vote in favor.
Mr. Nyman,
Yes.
Mr. Canavo,
Yes.
and Mr. Parisi?
Yes. We've heard our decisions favorable. With Bill, if you'd stamp and sign those plans, and we could get a draft decision to us, that would be appreciated.
Yes, I will. Thank you very much. Thank you for all of your attention tonight on all these matters.
Thank you, Mr. Chairman and members of the board.
All righty. Now we're finally moving into our 2 hearings. New business. The first, the petition of Suzanne and Frank Kinsey, appeal of building permit 20-478 at 105 Wingashiek Road. I believe they're represented by Attorney Handley.
Mr. Chairman, just for the record, I'm going to recuse myself on this.
All righty, thank you. James, you'll be hearing this. I see Attorney Handley. We'll bring him in as a participant.
What is the noise?
You need to unmute yourself. There you go.
Hi, this is Mark Handley on behalf of Frank and Sue Kinsey. We're here to appeal the building permit. I've spoken, can you turn?
Address.
We're here to appeal the building permit that was issued for 105 Wingashiek Road. I spoke with Mr. Sanborn about it, and I guess my concern is that the plans that were upon which the building permit were based, they do not show the ramp that is identified in the notations on the plans and shown in part in the elevation drawings. But the description of the ramp as well, if you look at the plans, the ramp is 13 feet high, has a 1 foot to 12 foot slope, which makes it approximately 100 feet long, is 26 feet wide, and that doesn't include the 42-inch railing that is going to be required and is not shown on anywhere on the plans. But the ramp with the descriptions that are carried in the notes and again not shown on the plan itself, the ramp necessarily encroaches in the required side lot abutting my client's property, and if you look at the site plan that's included with the permit plans, the roadway, although it's not reflected as a ramp on the site plan, comes to within about 2 feet of the property line on my client's side, and that is necessarily an elevated ramp, akin to a highway ramp. I spoke with Mr. Sanborn about it, and he wasn't definitive, so we felt the need in order to be clear and not lose rights with respect to a challenge to a ramp that may be built under some revision to these plans, or may be sought by the applicant upon approval of this building. The concern was that under Chapter 40A, Section 10, a variance is appropriate where, owing to the topography or the structure, a hardship would be imposed. And if this structure is approved by this board with the garage bays opening a foot and 1 foot 9 inches from the edge of the required side yard setback, there is absolutely no room anywhere for this driveway ramp to go without violating the required side yard setbacks in this ordinance. So.
Okay, thank you. I'm going to go to Mr. Sanborn at this point. I know there is some questions.
Thank you, Mr. Chairman. I'm not sure if Attorney Hanley has received the memo from Red Barn Architecture that we received on March 23rd in our office. Okay, I will make sure that gets forwarded to you. On that, it's a memo from the architect. After we talked, I had requested that they provide us more details on the plans for this ramp. They have agreed that the ramp is in the setback and they're going to cut it back out of the setback. And they agreed that they will give us structural plans on that showing that prior to construction. I probably shouldn't offer this, but I'm going to offer it up, that we continue this meeting, the board continue the meeting, because Attorney Hanley is working under the law, and I don't want to see him give up his rights. Truthfully, I can try to put this up real quick to show you what site plan looks like. I hope. 1 second.
Tommy needs some time to consult.
You need to read it.
This is the site plan that was submitted to me, and you can see this is the, if you can see my pointer, I hope. This is the property, the setback line, and what they've done for this plan is just taken and ran the setback line and erased everything in between it. With this plan, I can't tell you whether they're going to be able to make that turn, or if this is going to work or satisfy Attorney Hanley or us at this point. So my recommendation is to continue this till we can get more plans and more details, and make sure that everybody's happy at the outcome of this.
So to be clear, yeah, obviously we want to protect his appeal of the permit. When the permit is issued, this ramp, because of this height we're talking about, would be considered part of the structure. Is that correct?
That is correct. And on when the permit was issued and what was given to us to issue the permit on, there was no ramp shown.
Right.
Showed a garage, and we didn't notice the elevation difference on the plan at that time. We assumed it was a garage at grade, but this garage is elevated. How much is a question too, but that's all stuff that needs to be worked out. That's why I kind of, at this point, think there's still a little more work that needs to be done on this before we can say everybody's satisfied.
Attorney Hanley, does that sound reasonable?
It does sound reasonable. There's also an issue relating to the fill. the site plan that's provided with this is devoid of topographical information, but the site plan that was provided or prepared for my clients on their property was prepared by the same engineer, and does carry elevation information, none of which appears to support the claim of 13 feet as the base grade. Everything is substantially below that. And on the plans as they're shown, it appears, if you look at it, although they talk about a base, a base elevation of 13 feet, there is a large area of gray that is unexplained. My client's concern is if that is fill. I mean, this is a dune area that is subject to a tremendous amount of wind action. And if they're talking, it looks to be about 6 feet of fill. And if that is in there, that needs to be addressed, I believe, and approved by the Conservation Commission. But it also, some consideration needs to be given to what it is that constitutes that fill and how it's being placed there in a dune environment, because it is subject to substantial winds, as I'm sure you all know, and what you put there today is not necessarily going to be there tomorrow.
Exactly, and I do agree with that. And when we have the revised plans come in with this ramp, conservation would definitely have to weigh in on that part of the permitting process.
Okay. What's our timeline here? This hasn't been torn down yet.
No, they have not started construction at all. They should be getting us plans. They didn't tell us when. At this point, I'm not sure what the timeline is, but I know we're not going to see anything by the next meeting or two. If it's acceptable, maybe put it off for a month to 6 weeks. And if something happened in the meantime, maybe we can agree to get it back on and if we need it. But I'm hoping we can resolve this whole issue.
At this moment, do you consider the permit issued or
The permit is issued, but the permit is waiting, and before construction can start, they need to provide us the structurals for this ramp and some structurals for the building itself.
Alrighty, so we're in pretty good shape then.
But we may stop them from doing that till we get these answers.
So I'd like to entertain a motion, if everyone's in agreement, to continue this to 5/13, which is about 6 weeks away.
Mr. Chairman, I move to continue the petition of Susan and Frank Kinsey, appeal of the building permit, number BLD 20-478 at 105 Wingashiek Road, to the May 13th hearing.
We have a motion
Second.
and seconded. Roll call.
Mr. Nyman,
Yes.
Mr. Canavo,
Yes.
Ms. Lichty,
Yes.
Ms. Pratt,
I'm
She
recused. Bill.
recused, she recused.
Oh, I'm sorry.
James.
I missed that. I'm sorry.
May 13th.
Mr. Gelati
Yes.
and Mr. Parisi.
Yes. Okay, you've heard our decision. We've continued this to May 13th. Hopefully, it seems like the building department's on top of this and getting the right information. And we can address it then or sooner if necessary. Thank you, Attorney Hanlon.
Thank you very much, Mr. Parisi. Thank you, Mr. Sanborn.
Okay, our last hearing of the night is the petition of John and Joan Morris seeking a special permit under 1.9 variances for side yard, rear yard, lot width, lot area, and lot frontage to allow the addition to rear of existing structure with deck off addition at 524 Washington Street. Anyone needing to recuse? Are we good? Okay.
I have a question before we get started, or maybe it'll just be addressed. I don't know if he's being represented by an attorney. I just don't understand why he needs some of the requested relief, that's all. From what I saw, doesn't look to me like we need side yard variance, lot area variance. Oh no, we do need lot frontage variance. It's an existing building. They need variance for lot frontage.
Yeah, I was confused about the relief requested as well.
I think
Okay,
there's
well,
two or three things in there they just don't need, that's all.
Yep. Well, let's let, I believe it's David Jakewith, the architect, is
Oh,
representing, I
sure,
believe.
okay. Yeah.
Do we have, there he is.
You have to unmute, David.
Now can you hear me?
There you go.
Yep, thank you. I agree with Mike.
Could we get your name and address for the record, please?
David Jakewith, architect, 81 Railroad Avenue, Raleigh, Massachusetts.
Thank you.
Persons are listening in, at least. I know John and Joan are very interested in this. And I will try and be as quick as possible because it's almost past my bedtime. So we're adding an 8 by 10.5 foot room, and that room is 13 feet above the backyard ground. If you've seen the site or look at the site plan, there's a severe drop between the street and their backyard. And the 13 feet even drops off further towards the back property line. And beyond this relatively small room is a 10 by 10.5 foot deck. And that gives them outside space without walking down a flight and a half stairs to their backyard, which they rarely do. And it's a one-story addition on the back. You can probably not even see it from the street. They have talked to some of their neighbors and they signed a petition in favor of this, all the drawings for it. And we're putting it on 4 piers. And I don't know what else I can say. It does approach the left-hand side setback and it encroaches into the rear setback. This used to be a barn for the house to the right, according to John Morris. And it is, all the lots along there are very tight and would need variances, just like this one would. Some of them have a lot more property going down towards the bay. The view is beautiful to the west and they want to enjoy it. I understand he's going to retire soon, so he needs a little bit more space. And that's the reason we're doing it.
Okay, thank you. I guess to clarify, I'm a little confused about the request. I get the alter and expand, I get the rear yard. Bill, can you help with these other?
Yeah,
requirements?
on the application, they're looking for a special permit to alter and expand a non-conforming structure. And they are looking for a rear yard setback and they are looking for lot coverage. And reviewing this right now, that is exactly what they should be looking for.
Okay.
Side yard would be a special permit because they're already into it. Rear yard's a new variance. And according to their numbers, they're exceeding lot coverage.
Yeah.
I'm not sure where the information came on the written ad.
Yeah,
All right.
'cause
So that's clear with everybody. We'll take public testimony. Anyone wishing to speak in favor of the application, please raise your hand. Anyone in favor?
I know John and Joan are in favor.
Anyone wishing to speak in opposition? Anyone wishing to speak in opposition, please raise your hand. If you're on the phone, you dial *9 and we'll recognize that. I see no one in opposition. So there'd be no need for rebuttal, discussion by the board, or are we ready to just go to a motion?
Yeah, it looks like a fine little project.
Yeah, I would agree. Especially since both neighbors to the left and right have signed saying they're in agreement.
Yeah.
Yep.
Seems fine. And those houses are, you know, the lots back there are small and they all drop down like that. So yeah, I think it's a good project.
Right. Ready
Okay,
for a
so,
motion?
yeah, to be clear, we're going for special permit to alter and expand, a rear yard variance, and a variance for lot coverage.
Yeah, okay, thank you. On the petition of Joan and John Morris seeking a special permit to alter and expand a non-conforming structure and variances for rear yard setback and lot coverage to allow them to construct an addition with a deck off it at the rear of their home. I do think that they are intensifying the non-conforming nature of their structure, but I don't think it's substantially more detrimental than the existing non-conformity. So I'd vote in favor of a special move approval of a special permit. And I think that the small nature of the lot and the drop off of those lots creates a hardship justifying a variance for the rear yard setback and the lot coverage. So I would move approval of the variances as well.
Motion made,
Second for the special permit, then second for the 2 variances.
we have a motion made and seconded for a special permit and 2 variances, roll call vote.
Mr. Canavo,
Yes, for the reasons stated.
Ms. Slicksby,
Yes on the special permit, yes on the variances.
Ms. Pratt,
Yes, for the special permit and both variances.
Mr. Nyman,
Yes for the special permit and yes for the 2 variances.
Mr. Parisi.
I'm voting yes on the special permit. There's an increase in nonconformity, but not substantially more detrimental. And I'm voting for both variances. There's certainly a demonstration of hardship owing to the shape, size, and topography of the lot, and I vote yes. You've heard our decisions favorable. We'll draft a decision for you and get it out to you as soon as we can. And Mr. Sanborn, if you'd stamp and sign those plans, and I'll write the decision.
Thank you all. And I
Thank you.
really like Bill's office.
Okay, folks.
luck.
Yep, thank you.
You're welcome. So as some of you have heard, I haven't seen your mails yet, but our next meeting was April 8th, and the newspaper got hacked yesterday, and there was no edition out online, and there was all kinds of problems. So consequently, our hearings didn't get advertised. It was supposed to be for the 8th. They're being re-advertised, but we have to move our next meeting to April 15th, which is okay in a way, because there's still 2 more weeks to April 29th for the next meeting. So it's not like we're piling them up. We luckily have a 5 Thursday month. But I will, to make it official, I'd like a motion to move the meeting of April 8th to April 15th as a special meeting.
Mr. Chairman, I move that we change the April 8th meeting to April 15th.
Second.
Made and seconded, roll call.
Ms. Slicksby,
Yes.
Ms. Pratt,
Yes.
Mr. Nyman,
Yes.
Mr. Canavo,
Yes.
Mr. Parisi.
Yes. Anyone else have anything they need to bring up at this time?
No.
No.
Everybody good? Everyone feeling
Yeah.
better?
Well, hanging in there.
I got my vaccine yesterday.
Yeah, you're on your way to immunity.
Hey.
That's
And
awesome.
I went to my first in-person city council meeting in Woburn,
Wow.
in City
Wow.
Hall. Yeah.
So they're doing them in person,
You're
huh?
having it in person.
Any word when we're moving to in person?
Nope.
How many people were there, Joe?
It wasn't a lot. I mean, there was only a couple of hearings and basic stuff. So I don't know, maybe 20 people, 25 people. But there's before Concom, and they're still doing remote.
Oh,
Yeah.
yeah.
Remote too, Joe, or just in person?
No, just in person,
Wow, I'm surprised.
yeah. So
Well, that's a light at the end of the tunnel, seeing
There's
that. they're starting to
something
speed up.
out there to make you feel hopeful. I would have rather, actually down in Woburn, I'd rather have stayed home.
Yeah, right.
All right, we're gonna need a motion to adjourn.
I move for adjournment.
Second,
Made and seconded, roll call.
Ms. Pratt,
Yes.
Mr. Nyman,
going home, yes.
Mr. Canavo,
Yes.
Mr. Parisi,
Yes.
and Ms. Slichty. I think I skipped you. I'm sorry.
Okay.
No, yes.
All right.
All right. Good night, everyone.
Good
Nice
night.
seeing you.
Everybody.
Have a good night.
Take care.
Take it
Nice to
easy.
see you all.
Thank
Have a
you,
good evening.
everyone.
Yep.
Later.